warm welcome to all our viewers who are wherever you are and whatever you're doing. Thank you for joining. So, if I were to talk about litigation, I think to simplify, be it any case, whether it is a divorce case, alimony case, or any type of case between husband and wife, normally the procedure is first you decide that you have to undergo this type of litigation, and then you approach a lawyer. A lawyer asks for documents, details, everything. There is a lot of back and forth that happens, and then finally plaint is prepared, plaint is submitted or filed in the court, and then the court gives you a date. This entire process, deciding that you have to go for so and so litigation and getting the first date in court, normally takes about 6 months. And this is just the beginning, just the trailer of what is going to be like in future. So, notice is issued, notice reaches the respondent, whether he or she takes it or not, whether she comes on the next date or not. There is ample opportunity that has to be given for the opposite side to respond. And so they take their own sweet time, and they can, if they want, they can delay it for about 6, 7, 8 months, 1 year, depending on the type of court is there and depending on the type of functioning and workload is there on that particular court. So 1 year is lost just to get the reply from the other side. I just forgot about the notice is the stage of evidence. During the stage of evidence, uh, you can prolong it as much as you can. There is no fixed timeline that evidence has to be completed in this time frame. So uh, evidences keep coming, witnesses, cross examination, chief examination, all that keeps happening. In between, there is an interim application, some interim relief is needed. So for that interim relief, the entire mini procedure is also followed, where the opposite parties reply, rejoinders are accepted, and then they argue on that particular point of interim relief, and then there is the order that is passed in that interim relief, and then your case finally. So sometimes a year goes by in just one interim branch of the main petition. So so and in between that, there is a appeal that might happen on an interim order. So high court might even stay your proceedings as well. So that is also a possibility. So that will also delay it. You will get it in your lifetime. Otherwise, it is like uh, a constant, prolonged test of
Your
proceedings that
patience.
test everything, whether it's your patience, whether whether it's your sense of the situation, whether it's your decision making, whether it is the system, whether it's your lawyer. So everyone gets tested, and most of the time, date by date battle that you have to go through and endure. So enduring it is the biggest challenge. There are certain expectation. People think that if court gives a particular date, that date will not change. But there are endless possibilities. Judge might be absent. There might be some strike in the court, which happens very often, more often than you think. There might be some condolence, some.
Called overnight, you will get
Yes,
justice overnight. This
yes,
this brings me to my own situation, wherein I thought after the decision of moving on or decision of filing for a divorce is done, for me to just end up in a case and see 100 cases been listed on the day when I was chair. And for the 55th case to just come in 10 minutes, where it was just reading out a sequence of number
yes.
1, 2, 3, 4, 5, 6,
So
7,
it
8,
can
9,
come
10.
quickly as well. Yes.
Yes, sir. And in 10 minutes, the 55th case has come, and my turn was only for 3 to 5 seconds, where I had to just go sign and disappear from the court. Was very, very fascinating to know that if at this pace my date comes and goes, I was essentially standing at a stage where in 2 years I realized I have not moved an inch. The dates have kept on moving. To get an order in the lower court itself, like Avnish ji said, could take 5 to 10 years. Trust me, if you start to go beyond this to higher courts and Supreme Court, your lifetime will get over. You'll probably not be able to move on. because in most, and
Also imagine that if a judge has to hear 150, 200 matters in a day, so how much time, energy, or uh, bandwidth of
effort,
faculties he has to go into depth of each and every case. So usually the focus of judges on every day in and day out, is just understand the matter or the procedure enough to get the next file called, and give next date for this existing file that
yeah,
is
yeah,
listening to. So
I
so
absolutely.
it is not humanly possible to handle all that workload, especially in big courts and busy courts, where even the judges are also struggling, the court staff is struggling, everyone is struggling, the litigants are struggling the most. Let's not have any doubt about that, because they are the ones who are suffering actually. But there is a lot of pressure on other stakeholders as well. So so if you think that your case will be understood in a span of whatever we are talking about, even that doesn't happen, because usually there is very less time, and by the time the court reaches the final argument stage, where the judge is supposed to hear everything and understand the whole thing in totality, even there, because the procedure has been so long, the matter has been distorted so much that a lot of things don't come before the judge, or get missed out, or some
I just
yes,
realized
please.
one important thing. I think everything is bought by experience. At the end of the day, it's the judge who is on trial. It's not the
Correct.
parties. The
Absolutely.
reason they put up so many cases is because of the, let's say, 100 cases that are listed. 50% of these cases will have either one party present or none of the parties. The remaining 50% will be cases where only the notices have to be issued. The remaining set of cases will be the cases where only an argument has to happen. The bare minimum cases will be cases where an order has to be passed. I think the judicial system has also learned through the process. They know how to effectively utilize the 6 hours of hearing or listening time that they have, also mature through the process of saying which case has to be given importance for that day for things to move on. I think what would help, if both the parties and the lawyers are honest, obedient, punctual, be present on all the times, remain on the fact, not make it.
This is very long, which is the case in matrimonial dispute. When we decide to go for litigation, we have this assumption, implicit assumption, that people will function as expected always. It doesn't happen like that. Even your perceptions, your attitude, resolve, or your determination will fluctuate throughout this span of 5 to 10 years. And this will make you make mistakes, which will even prolong the process, or at least increase your pain in the given process. So, and same goes for your lawyer as well. He will not be at his best every day. He will not give you the best advice every day.
Will be executed or followed respectfully. Does not
Mhm.
happen that way. I
Yes.
think you will see a lot of instances, a lot of orders are not even followed, be it the visitation order, the alimony order, the maintenance order, and so on and so forth. I think the more you get into the system, go through the process, the more you will realize how painful the entire process could be. While you are only dealing with the pain of being separation, and eventually when you get separated, the pain will only increase, because at the end of the day, nobody wins. But during the adopt some of the Western culture, but we have not adopted the maturity of the Western culture, where living in peace, moving on in peace, is more important than fighting, litigating, dragging, extending
Correct.
all the cases and running it for the lifetime.
So Nida Fazli's share sums up the entire litigation. It goes like this: कोशिश कर, रास्ता भी चुन, उम्मीद भी रख, फिर उसके बाद थोड़ा मुकद्दर तलाश कर. So you have to invest a lot of effort, money, right people, right contacts, and everything. Plus, you have to hope and pray that something positive will come out. And you can't pray that something positive will come out very soon. So that is a given.
As so for all the subscribers or all the listeners who are listening to this channel, you would have all realized it's probably not easy for us to present, talk about everything and anything with respect to the litigation process.
Yes.
Our attempt has been to give some clarity on this process itself. We're happy to get feedback, listen to you. We'll also answer to all the queries, but it's a small
And
effort from
comments.
our side
Yes.
and comments.
Mm,
Small efforts
mm.
from our side to burst some of the myths that people have during this entire process and also help them be more educated and take an informed decision. This is a
Yes.
channel where we are not advocating for anything. We are just making people aware of the pros and cons of what happens. It is not targeted at anyone. It is a system where we try to be empathetic to the judicial systems, to the people who are going through the cases, to the lawyers who are fighting this entire processes, because it is not easy for anybody who's part of this entire ecosystem. Some are emotionally drained, some financially, some physically, and some mentally. The only word that we would like to say is take care, stay positive. In our next episodes, we talk about the various stakeholders those are involved in this entire processes, how they make or break the changes it is going to be in this entire process, how they could help you help move things better or not help you make it worse. Again, it will be an
Absolutely.
attempt to educate, advise, and take an informed decision. Till such time, stay blessed, take well, be strong. There is a way. You have to find the way out. Thank you. Do like and do share your feedback, comments, and questions. Take care.
Bye. Take care. Bye.